All right. Well, looks like we're live. Welcome, everybody, to our latest Level Up FBFK Law webinar discussion. And my name is Dave Cohen. I'm a director here at Level Up. We're very happy to have you online with us here. If you're live and if you're listening to the recording, welcome as well. And we're really excited today to be doing the second kind of get together, Steve and I here, in terms of this webinar conversations. To discuss a topic that we saw on the radar a few months back, and it caught our interest, and we started talking about it and decided that it would be good to share with all of you in terms of our interpretations and kind of our postulations as to the effect this might have on the privacy and data security landscape. So we're going to talk about that today. But before we get started, I'd like to introduce our guest, Steve Tolan. So Steve is an attorney in Texas, and he's the head of the Austin office at FBFK Law. So Steve, welcome. And can you tell folks a little bit about your practice and a little bit about your background?
Yeah, thanks, Dave. Good morning. It's so great to be doing this again with you, and we've certainly picked an exciting and somewhat challenging topic, because we're just starting to unpack it, I guess, right?
Yeah, exactly. Yeah.
And I'll just give this caveat to our participants or people joining us. We're grateful to have people on, and we're not going to bore you with any Supreme Court. We're not going to break down any cases, I promise, but we will talk a little bit about Chevron at the beginning. I run our Austin office. I head up our practice groups for FBFK Law and data privacy and security, as well as white collar and regulatory law. I'm a certified SIP designation and data privacy, and then have a legal specialization, board certification in criminal law. So this area, now that we're talking about litigation around data privacy, is very much exciting and in my wheelhouse, so to speak. We are in Plano, Dallas, mostly our FBFK main office. And we have offices also in Houston and Orange County and Costa Mesa. We're growing a lot out there. So that's exciting. We do a lot of California work and with their Attorney General's office. Most of my day, centers around data privacy, cybersecurity, data protection matters, and counseling clients on legal compliance, risk mitigation, investigations, civil and then criminal, and then data breach responses. About 25 years or so, a lot of federal court time for me. And so I'm not exactly excited about the Chevron decision per se, but I spent a lot of time in federal court. So, maybe I'm not as chicken little, the sky is falling perspective as others. But anyway, it'll be interesting for us to talk about it today. So thanks for having me.
Absolutely. Thanks, Steve. And I should share with our listeners that Steve and I met at the IAPP Global Privacy Summit back in the spring, and started talking and really got into the kind of collaboration, the different aspects of the work we do. I'm not an attorney. I work in the operational privacy compliance world. So here at Level Up Consulting Partners, we help our clients set up their DSAR systems and to do data mapping exercises and to kind of understand within the IT systems and the actual operations within companies how to really implement privacy compliance and data security compliance measures so that they're being good data stewards of their customers' personal information. And of course, Steve's on the legal side, so we had a lot to talk about. And so this topic came up. I'll just kind of tee it up here a little bit, Steve, and then I'll let you talk about the Chevron decision itself, which was June 28th, 2024, is the Loper Bright Enterprises v. Raimondo decision at the Supreme Court, and it started making news in the privacy compliance world because it talked about a shift in authority or power from what was previously the Federal Trade Commission's ability to more clearly define unclear elements of language in privacy law, and it sent that authority back over to the courts, as it were, as a quick summary. So that's kind of the top level highlight, and we started to think, well, how is this going to change the privacy and data security compliance landscape for our clients? And so, Steve, can you just kind of tell us a little bit about what this Chevron decision is, what it was, and then we'll kind of get into what we think are some of the likely consequences or possible consequences.
Yes, absolutely. So before we kind of break down Chevron, I'm gonna throw a little curveball at you, but I think it'll help kind of break this stuff down. remember the movie Fast Times at Ridgemont High? One of my favorites.
Yeah.
All right.
Yeah.
You can remember Jeff Spicoli, the character, sitting in civics class with Mr. Hand. And so let's go back to civics class quickly here. So civics class, you learn that Congress makes the laws, right? And the federal judiciary's job is to interpret the laws. And then regulatory agencies like the FTC, for example, they're given the power to enforce laws from Congress through the Administrative Procedures Act. So that was the crux of this fight. That's what Chevron stems from. And then Loper Bright overturned 40 years of precedent from Chevron. So Chevron at issue involved environmental regulation, which interestingly enough, the former head of the EPA, 1981 to 83, before Chevron in 84, was Neil Gorsuch, Supreme Court Judge Gorsuch's late mother. She, under the Reagan administration, ran the EPA. So this litigation stems from that. And in that, there was an ambiguous term, and the courts decided to give deference, and that's a key word here, deference or weight, to the environmental agency or a regulatory agency under the Administrative Procedures Act, and said, look, even though before that, Congress's job is to make the laws, court's job is to interpret it, we're going to let you, agency here, the EPA in that example, interpret this ambiguous term and apply it. And at the time, this case was not some major decision. I mean, there's major decisions we think of, Brown v. Board of Education, Plessy Ferguson, Roe v. Wade, et cetera, right? That this is not one of those cases. The reason we know it now is 40 years, this case has been cited, I think, an astonishing 18,000 plus times. It's a massive amount. And so it kind of grew into this case about agencies, regulatory agencies at the federal level, have quite a bit of power to determine ambiguous terms. Now, you get to where we're in the 2000s. Now we're in late 2000s. Technology is emerging at breakneck speed. That's kind of no-brainer comment there. But it's important to note we're sort of intentionally drafting Congress's data privacy, cybersecurity matters that are intentionally kind of broad. And they're allowing room and space for regulatory agencies to interpret some of these ambiguities and use their expertise as technologies emerge. But there is a pushback on that, and that's what these cases are. This Loper Bright case, strangely enough, is really a small, narrow example of regulatory oversight, if you want to call it that. It involves the fishing industry, commercial fishing industry, specifically, ironically, the herring industry. I say that it's like lawyers have this PTSD when they hear the word red herring, because that was always a law school pun or joke, like don't chase the red herring. So I can imagine all the bad jokes that are going to happen in law school now as they teach the Chevron decision. But in this Loper Bright case, they said, look, Chief Judge Roberts, who wrote the opinion, said, no longer is deference supposed to be given to an administrative, under the Administrative Procedures Act, to a regulatory agency. We are done with that. That's Congress's job to create a specific law. If it's ambiguous, they didn't create a very good law, and it needs to go to the federal courts, and courts are tasked with determining what the ambiguity is, settling that tie, and making a decision. The reason that's so significant, as we know, is because a large chunk of what we'll talk about in a second in data privacy through FTC Section 5 and Section 18, the rulemaking section that's not as often thought about, but an important part. And then, of course, Graham Leach Bliley in financial services industry, HIPAA, through U.S. Health and Human Services. All those areas now are going to be impacted because they've been given sort of a broad mandate to craft interpretations of intentionally ambiguous rules that now are out the window. So now in this post-Chevron world, I'm not trying to sound post-apocalyptic, but I mean, that's the reality. It's a very different landscape than it's been for the last 40 years. That's where we are now. So now we're going to look at Congress with this tension point of they need to craft more specific, narrowly tailored rules and regulations to address data privacy and cybersecurity, but they also need to allow some space for emerging technologies. And that sort of tension is one factor we'll talk about today. And then the other one is now, what does this mean for data privacy moving forward? Are we going to see more litigation? The answer is yes. How and in what ways we'll talk about. But that's Loper Bright in a nutshell. No longer are agencies allowed to determine for themselves what an ambiguous provision is. They can enforce it, but if it's ambiguous and you can't settle it, then it goes to the federal judiciary to decide.
Yeah. So that's great. Thanks for that. Actually, very concise summary of what the decision was and what the potential consequences are. So, Steve, I think really for the people on the line today, what we want to talk, we're going to try to keep this practical.
Right.
So, we both work with clients who are managing a lot of personal information within their systems, want to do right by the law, want to do right by their customers. So, what we really want to stay kind of focused on is what does this mean for them in terms of their priorities? How is this going to affect their compliance challenges? And so let's start talking about that. So it seems to me that one of the things that may shift here is the length of time it's going to take, for instance, for an agency like the FTC to be able to put together allegations with regards to violations, and with the ability of the rulemaking specificity now kind of taken away, it could take longer for them to issue these allegations. Would you say that's a correct statement? And how do you see that kind of playing out?
I do think that's a correct statement, and I think it plays out in a couple different ways. First, let's address this issue. Consent decrees, which are in consent orders that come from decrees, are administrative agreements that don't involve courts. So the opinion, I don't know if it clearly states this, but it is without question that consent decrees already in existence are not at play here. So you can't go back and relitigate those. That's a settlement you made out of court. And in fact, it doesn't even involve Chevron, post-Chevron, any type of judicial analysis at all, because you did all these things and you settled them out of court before a lawsuit was even filed. So in that instance, that will stay the same. I think there was some bantering back and forth at the beginning, right after Loper Bright came out, and the answer is unequivocal. No, the consent decrees are not affected by that, or orders. Obviously, can't relitigate those.
Which, by the way, can I just interject in there for just a quick second? With regard, if a company is in the unenviable position of being contacted by the FTC, with regard to us, right? Yeah. There's going to have to be a decision at some point whether to work with the FTC if it gets to that point. First of all, many alleged violations are settled even prior to consent decrees, right?
Correct.
So that can happen. But if it does get to the point where we're starting to discuss consent decrees, companies have this decision to make as to whether to work on a consent decree or to maybe take it to court and take their chances in court, right?
Right. And I want to go back and answer your other question as well, but let's talk about that because they're all so connected, right? They're just all kind of part and parcel of the same analysis here. That I think that one impact here is that the FTC or other regulatory agencies are going to lose some leverage, right? So court, there are a lot of things we don't know about federal court at any one time. It's very fact specific. I can tell you in 20 plus years of being in federal court all the time, we know these things to be true. It's expensive. It's not efficient, right? It's time consuming. You can't necessarily control the clock. It's very difficult to put your foot on the gas, put your foot on the brake. I mean, you just kind of lose control there once you file a lawsuit, and it's unpredictable. So those three factors really are always at play anytime you're talking about federal litigation. And so I think it is the FTC, let's use them as the example we'll talk about. They're going to know that as well, right? Companies aren't just all excited to say, oh yeah, well, I'll thumb my nose at you, regulatory body, and I'll see you in court. I mean, they know that those can also often be hollow words. That being said, though, if there is a significant amount of money potentially vis-a-vis administrative fines or injunctive measures being proposed by the FTC,
costly,
and that could be very costly to a company, quite obviously, right? And the remedial measures that could be proposed in that consent conversation, the consent decree conversation, if those are significant enough, there is a cost analysis now that wasn't available before Loper Bright decision that's now available. And that analysis essentially for a company is, all right, it's going to cost us this amount of operating costs being in business if we're enjoined during this time. It's going to cost this amount for these remedial measures to take place. We feel like they're a little bit draconian in these ways. Okay, how much is that going to cost us? Let's talk to our shareholders if we're a publicly held company, or privately to our investors, versus going to court and how much that might cost, et cetera, right? So now that's a factor. You didn't have that analysis before. Right. And then I think what you'll see is that companies will start pushing back certainly let's use our FTC example, to the FTC and say, look, we think these are a little bit harsh here. We'd like to, we have some more leverage than we had before. We don't necessarily want to go to court, but here's what we're thinking. So I think you're going to see more of that analysis, right? But does that answer your question there on that? I think that's
Absolutely.
what you're saying.
Absolutely. Yep. Yeah. And then, Steve, I think the other kind of thing that we were talking about and preparing for this conversation that really want to be looking at is how might this affect companies' evaluations and their prioritization in terms of their compliance activities with regards to what's on the potential roadmap for federal violations potentially, or state law compliance issues that they're going to be dealing with. So there's this interplay, right, that every company has in terms of trying to look at the roadmap of all of the different requirements, legal requirements, to be good data stewards, and that ratio between the federal and the state. And so, given that it seems the federal enforcement actions might be slowed down a little bit, at least initially, by some of these changes. Would you say that state agencies might step up potentially and kind of fill that gap, looking to keep companies in line and make sure that companies are doing right by their stewardship of the personal information? Do you see that as a potential outcome of this decision?
Absolutely. I don't think it's a stretch to suggest that. We see that in a lot of areas. Now, these are we certainly don't want to launch into any non-data privacy topics, but we're talking about federal regulation in general. And so politics comes into play a little bit with this stuff too. But we're seeing that in other states about, say, for example, border security, where, you have this tension point between the federal government regulating things and state government stepping in and saying, look, if you're not going to take up that space, we're going to do it. And we can debate whether that's sound policy or not, or legal or not. But the same sort of a thought process could go with data privacy. If Congress, which isn't exactly this shining example of efficiency and cohesiveness and collaboration, I don't think it's a stretch of credibility to suggest that Congress is probably not going to be able to get their act together to enact some pretty specific data privacy regulations, or one omnibus federal data privacy bill or practice anytime soon. And so,
by the way, Steve, just to interject quickly on that point there, another outcome of this decision is that it's going to require the bill making process, the crafting of legislation within Congress, to be more specific, right? It's applying pressure for legislators to be more granular in their language in the crafting of these federal laws. And to your point, Congress not being the most efficient process anyway, it's an additional burden, which one can only assume is going to make it less likely that, let's say, both sides would agree on those technical details, those technical specifications, and it's just going to plain take longer. There will need to be more technical expertise involved in the crafting of the legislation. So all that seems to point toward unfortunately, lesser likelihood of federal legislation being passed. Would you say that's accurate?
I do. I think that's very accurate, Dave. I think it's well said. I mean, I think they're going to have to be more specific, because if they want to get around this issue of these regulations they put forth being litigated all the time in federal court, they're going to have to be more specific, right? Mm-hmm. They need to be less ambiguous. That's the standard.
That's part of what we're talking about. Yeah.
Now, some of these things may not. You may not see, like, for example, under Graham Leach, the FTC, often it's an ambiguous term sometimes about financial institutions. What's a financial institution? Or and under DHHS for healthcare, under HIPAA, like, what is a business associate? Mm-hmm. I don't know if Congress is going to go back and narrow those definitions down. They probably won't. I think that's what we can talk about, what that might look like in court if someone were to challenge that. But that may not be such a big issue. I think those are in play, but maybe that's not an example of what's litigated. I think some potential areas where Congress needs to go back are somewhat in data privacy, but in cybersecurity matters, where particularly in California and in Texas, where you have to provide appropriate security measures or appropriate measures to protect data and information. what is that? What's an appropriate technical measure? That's an example. Some of the requirements for FTC or under Graham Leach about notice requirements in the event of a breach. We may see Congress come back and be more specific now about what needs to be included in that. Because you've got some conflicts. You got the SEC maybe has like a 4-day rule, and then you've got and states requiring something else, and Graham Leach requires something else. And that's just on the timing of when you send out the notice, right? And then you got all the details about the content of them. So it's sort of unfortunately, it's a landmine of like different subject areas wherein Congress may need to go back. But yeah, I think that's what's going to happen. Now, go back to your original question. What are we going to see? What do we expect to see states do?
Right.
Are states going to fill that gap? I think they will. I think a potential outcome soon is going to be states that have already kind of led in this area, like California has a very robust enforcement practice. It's also, well, it depends on your perspective, but I think a lot of business owners, at least our clients that we talk to in California and that we advise, will tell you that they're receptive, they're open to communication. It's kind of a fluid conversation and process. They're certainly not trying to hide the ball. And so I think you'll see an example of a attorney general's office in a state taking leads in that. And maybe that is an example at the federal level of where a state like California may come in and lead and continue to help Congress adapt more specific, narrowly tailored regulations around data privacy and cybersecurity matters. I also think that states like Texas, where our House Bill 4 for our new Data Protection Securities Act is in play now since July 1st, and it'll start being enforced January of 2025. We've got $7.5 million invested in that over the next couple of years. We've got 12 employees or more at the AG's office now, and I think you'll see more of that. I think now that Texas will likewise, in turn, their AG will go back and create more specific and more active role, I think, is what you'll see states do.
Steve, I was just reading an article this morning on LinkedIn about, I don't know if you saw the $1.4 billion settlement with Meta for violations under the Texas biometric data law.
Yep. So that is the main area of focus now from Jump is biometric data like that, or data brokers is kind of the first area. Over the next 6 months, most of the AG's concentration in Texas is going to be about data brokers. And there's target letters sent out to 60 companies, 60 data broker companies at the beginning. And then we're just starting to see the impact of that. So that's a great example, I think. So an interesting question, I'll throw it at you, Dave, is, so now we'll see federal courts can still consider agencies' opinions and agency, I guess, interpretations of what you might call an ambiguity. They just can't give deference to it. Now, that concept, and it's written in the Loper decision, is this concept called Skidmore. Skidmore is just the name of an old case, but Skidmore does say that agencies, that the fact that an agency has in the past interpreted a regulation a certain way, that's relevant, that judges do consider that. So you can brief the judge, you can, in your pleadings, you can educate the court, you can file briefs and motions educating the court. There can be friends of the court or amicus briefs filed. And then also under the Skidmore concept, Judge Roberts talks about it in the Loper Bright case. These issues about how an agency has interpreted things in the past, those come into play. The key, though, is it's not given deference. So a lot of judges will just still consider that and then make a decision. Are state courts going to do that? Are they going to because state courts in the past have adopted sort of a Chevron concept from state regulatory agencies. We see that a lot in Texas. We'll say, well, this state regulatory agency has always done it this way. So kind of taking that Chevron deference model, even though they don't quote it because it's, federal law isn't necessarily relevant in a state lawsuit. They sort of cite that concept or that idea of let's give deference, weight, special credibility, start off on the scales a little higher if you're the regulatory agency there.
Yeah.
Now, post Chevron, will state judges do that? I think you'll see a lot more challenges to this, probably maybe at the state level first. You can, would say forum shop, and you can kind of choose your forum a little better, a little more predictable that way. Probably less, it's arguably faster. It's less, well, not always, but can be less expensive, potentially more predictable. So we might see that. We might see more litigation in state court at the beginning around these issues. And then depending on how robust, or if there's an AG enforcement mechanism, a lot of states don't have that, but many states do. Texas and California obviously do. So we'll see. But I think states will lead, and the states that have AG's offices, I think they'll take I'm sure, Texas is probably excited, right? Our AG, it's low hanging political fruit. If you're an attorney general in a state, to protect the consumer and pay attention to these issues. And I think we'll see more of that.
That's what I think as well, Steve. I think this could be actually a boon for state attorney general's offices to step up, fill that gap, as it were, if there is going to be a slowdown at the federal level. And another thing I was thinking the exact same thing, Steve, is that I'm going to guess there's going to be a fair amount of politics involved, at the state level, going back and forth. And another thing that we see, and trying to think about this from the perspective of our clients and what they need to do practically to be able to do their best to be in compliance with the laws that they fall into scope under, is look at the proliferation of state privacy laws that we saw last year. Don't necessarily expect that to slow down next year. It seems like what happens is states are looking to their neighbors. And if one state comes out with a state privacy law and it's, the adjoining state doesn't have it, there tends to be, what are my neighbors doing kind of thing. And that's how these laws proliferate. So I would expect to see more active state AG offices. I would expect to see more state privacy laws and cybersecurity laws emerging in the coming year. And regardless, I think one of the big takeaways here, Steve, is that this development is going to require all of us, the privacy professionals, from the legal side as that you sit on, from the operational side that I sit on, from the private sector side for those that work in the companies that are working to stay in compliance with these laws, is to keep an eye on the new precedents that are going to be set. Right. It's going to be back into the court. It's going to be, a shift in the way allegations are coming out of the federal agencies. So regardless, I think we're going to see new decisions and more precedents being set. So if we had a kind of a marching orders and a kind of a roadmap previously, the thing to do now is to stay tuned and to watch what happens and to see if there is some of that replication going on that I was mentioning a moment ago, where something, a development that happens in one state gets looked at as a precedent, and it starts to promulgate and become, for instance, like a common law understanding of the detail of what the privacy law, for instance, requirements are.
I did beautifully said, Dave, because that's exactly right. That if you're looking for if you're a business owner, you're looking for a takeaway. I think both of us talk about this a lot. We want people to leave these things, hopefully not, regretting that they can hear our voices in their head for another 20 minutes or so, but that they have some takeaways, right? So some actionable takeaways, and no matter which side of it you are, whether the legal side or the management architect side that you sit on, we need to not only pay attention to the decisions that are coming out now in courts, but there is some benefit. So in the past, if you see an action that takes place from a regulatory perspective, you don't always know the rationale behind it. You don't always know what was the exact reason why that agency made that decision. How did they think that was an unfair or deceptive practice exactly, right? And now in federal, if these are decided in federal courts, these issues about an ambiguous term, for example, like you said earlier in our conversation, that there is an impetus now, a requirement, I would say, on not only in Congress when they're making these laws, but in the court when they provide a basis for siding with whether it's the regulatory agency or the private party, how they got there, right? You can't just come in and say, well, that's the way our agency's done it for years. That's just how it goes. Take it or leave it, pal. Those days are gone. So now the agency in court in their pleadings and as part of any agreement and their arguments will have to explain that the basis for why they think that specific action is deceptive, or that notice isn't fair, or that is not a business associate. This is the way it's defined. those kinds of things will have more specificity to them. So that's the stuff we really need to pay attention to. I mean, a takeaway is to not only just pay attention to what the decision is, but how they got to that decision is critical. Because if you're thinking about going to court, or you're advising and risk mitigation to a client about should we go to court, should we not, you're going to want to be able to really understand the intricacies of how the court got to where they got to. I don't know if that's grammatically correct, but how did the court arrive at their decision, I guess is the more appropriate way to say that. Yeah. That's a key takeaway, I think. And so we're all going to be paying attention to that. We got to be more intentional also. And I think you're going to speak to that, right? As you're creating and crafting policies moving forward, you got to, I don't say you go back to the drawing board, but you almost have to go back and look at your foundation and start looking at your scaffolding. If you're doing this architecture analogy I'm trying to run with here, go back and at every step, reassess, right?
Yeah, 100%, Stephen. That's actually a good segue. And I'm just noticing at the time here, we're just about out of our 30 minutes. Two things. One, stay tuned here. We're going to try to, as these decisions come out, and we think that they have some weight and are things that should be on our clients' radar, we'll be continuing to share them with you here through this channel. So stay tuned here for upcoming sessions on those. But to your point, Steve, yeah, I like to end these on basic foundational principles. What we do every day in, day out with all of our clients. We enact data mapping exercises so people can understand where their personal information is being collected, where it's being stored, how it's being processed, how it's being hopefully deleted on a regular schedule and managed properly, and setting up those systems so that they have good relations with their customers and with their third parties, so that there's a clear understanding and legal documents in place, procedures and policies to be able to guide people into good data stewardship practices. So back to the fundamentals, always a good idea. So with that, thanks so much, Steve, for taking a little time out of your day for this conversation. It's always great to talk to you. It's always great to hear your insights.
Likewise. Thank you. And so critical too that I think attorneys and technology partners and privacy experts like yourself on the creation side work together and continue to communicate about what we're seeing and the reasons we're seeing it. That's so important.
100%. So for everybody out in the audience, if you're with us live, thanks for spending a little time with us. If you're listening to the recording, thank you for making a little time. Hope you found some good insights and some good practical takeaways. And until the next time, we'll now sign off. So thanks everybody for joining us.
Thank you.